Imagine a division collegiate athlete walking into the locker room on a Tuesday afternoon.
Right.
You know, the smell of turf, tape, sweat, it's already in the air.
Yeah, totally sets the scene.
And before they even lace up their cleats, they reach into their locker and strap on a wearable biometric monitor.
Like it's nothing.
Exactly. It's just part of the uniform now. So they go out, run through this grueling 2-hour practice, and every single heartbeat, every acceleration, even their sleep cycle metric from the night before, it's instantly beamed out.
Yeah, it's a constant stream.
It really is. That data flows seamlessly to the strength coach's tablet. It goes to the athletic trainer. It gets, aggregated by a third-party analytics platform sitting on a server halfway across the country.
And people don't realize how far it goes.
Right. And under recent NCAA policies, it could potentially be flowing right into the hands of sports betting aggregators.
Which is just wild to think about.
It's a massive, continuous stream of the most intimate biological data imaginable. Then a few years later, that athlete graduates. So here's the question for you. Where does that data go? And more importantly, who decides what happens to it?
Well, the incredibly unsettling answer is that right now, in the vast majority of cases, it is not the athlete who decides.
Not at all.
The data essentially outlives the athlete's collegiate or, professional career. It's just sitting on proprietary servers, being modeled, aggregated, and potentially monetized.
Well, the human being who actually generated that heartbeat has absolutely zero control over it.
Zero. None.
Which is exactly why we are taking a deep dive today into what is rapidly becoming known as the wearable Wild West.
It's such an accurate name for it.
We are pulling from a massive stack of recent, really heavy-hitting sources for this. We've got Carson Taylor's August 2025 regulatory review piece, a December 2025 PMC paper on co-ownership.
Which is fascinating, by the way.
Oh, totally. We're also looking at a June 2025 Foley and Lardner analysis, the November 2025 sports litigation alert, and a massive January 2026 review of this whole wearable Wild West concept.
That's a lot of ground to cover.
It is, but our mission today is clear. We are going to explore the urgent disparity between the biometric technology athletes are, mandated to use every single day and the lagging privacy regulations that are supposed to protect them.
Right, the laws are just way behind.
Way behind. And we aren't just going to admire the problem. We are going to uncover the actual playbook for taking back data sovereignty.
Which is so needed right now.
As a former collegiate athlete myself, I can tell you mandatory tracking feels completely normal when you are inside that locker room. You put the strap on because the coach says so, right? You want to make the starting lineup.
You're not thinking about data privacy.
No, you don't think about cloud servers or third-party data brokers. And that is why having your tech policy background here today is so crucial. We really need you to help us navigate this legal labyrinth.
Well, the normalization of this technology is exactly what makes it so vulnerable to exploitation, honestly.
Yeah.
When you step back and look at the sheer scale of what is being collected, the legal black holes become glaringly obvious.
So what are we actually talking about in terms of scale here?
To understand why the stakes are so high right now, you have to look at how ubiquitous this tracking has become. We're talking about roughly 80% of student athletes being tracked today.
80%, that's almost everyone.
Pretty much. Over 50 top NCAA basketball programs are using in-game live tracking technology.
But yeah, not just in practice, the actual game.
Live in the game, real-time data. And in the pros, catapult tracking technology is embedded in every single NFL locker room.
Wow.
The NFL Players Association has a massive league-wide partnership with WWOOP. And the timeline of this adoption is what really catches the legal system off guard.
Because it happened so fast.
Exactly. 25 years ago, this volume of continuous biometric data didn't even exist. 15 years ago, it was the exclusive, highly guarded domain of elite Olympic, which is incredibly sensitive information.
Right. But that is somehow classified as just unprotected athletic data.
Yep.
The mechanism of collection completely strips away the legal protection of the exact same physical body. It's like being forced to leave your physical diary open on a table for anyone to read.
You are hitting on the core vulnerability right there. The law currently cares more about who is collecting the data and how they collect it than the actual sensitivity of the data itself.
That makes no sense.
It doesn't. And there are essentially 4 massive legal blind spots where this athlete data falls right through the cracks. The first one is IPA. We all assume HIPAA covers this because we associate heart rates and sleep cycles with health.
I mean, we sign those IPA forms at every doctor's office. It seems like the obvious shield.
It seems obvious, but IPA relies on a very specific legal mechanism. It only applies to legally defined covered entities, so hospitals, doctors, health insurance plans that transmit health information electronically.
Okay, so university athletic department.
Is not a healthcare provider billing insurance companies. Yeah. The strength coach monitoring an iPad on the sidelines is just an employee evaluating performance.
Wow.
Because the athletic department is not a covered entity, IPA simply does not apply to the data sitting on that coach's iPad or the third-party server they use.
Okay, so that completely strips away the federal medical protection. But what about FERPA?
Ah, FERPA, the second blind spot.
I mean, a student athlete is, by definition, a student. The data is generated on a university campus during a university-sanctioned activity. Why doesn't the Family Educational Rights and Privacy Act lock this down?
It comes down to how universities strategically classify the data to avoid FERPA.
Oh, they do it on purpose.
Well, FERPA is designed to protect educational records, your transcripts, your disciplinary history. To sidestep this, institutions classify a live feed of your acceleration speed or your recovery metrics as operational athletic data.
Operational data.
Right. They argue it is no different than the coaching staff recording video of a practice to evaluate a play. It is a tool for the team's daily operation, not a metric of the student's academic journey.
That is such a loophole.
It is. By keeping it in that operational gray zone, they prevent athletes from invoking FERPA rights to control or suppress the data.
So if HIPAA is out and FERPA is sidestepped by calling it operational data, athletes are essentially legally naked at the federal level.
Pretty much.
Does the Constitution offer any cover here? I saw the Alicia Jessup paper from Pepperdine University in our sources, and she was diving into the Fourth Amendment.
Yes, the third blind spot. Jessup's work explores a really fascinating constitutional argument. The Fourth Amendment protects against unreasonable searches and seizures by the government, right?
Right.
And public universities are state actors. Her theory questions why a state university can mandate the continuous, warrantless extraction of your internal biological data just to play a sport.
Oh, that's a great point.
If the government cannot search your physical pockets without a warrant, why can they mandate a sensor that searches your internal physiological stress responses?
That is wild to think about.
It is a brilliant mechanism to challenge mandatory tracking, but unfortunately the courts haven't definitively settled it to provide blanket, nationwide protection yet.
Which means we are left relying on individual states to step into this massive federal vacuum.
Which brings us to the fourth and final blind spot. The chaotic state patchwork. The attempt to pass a federal National Biometric Information Privacy Act actually failed back in 2020.
I didn't realize it failed.
Yeah, and because Congress didn't act, your rights to your own bodily data now entirely depend on your zip code.
So it changes depending on where you are.
Exactly. If you play in Illinois, you are protected by BAPA. That law is incredibly strict and includes a private right of action, meaning an athlete can directly sue a company for mishandling their biometrics.
Okay, so Illinois is good.
Yes. Texas, Washington, and Colorado have specific biometric laws as well. But if you play in California or Oregon, biometrics are just folded into broader, more general privacy regimes that don't offer the same targeted teeth.
For anyone listening who travels for work, just apply this to a collegiate schedule. A team from Illinois flies to play a team in Florida. Are the players' fundamental data rights literally shifting in midair on the team plane?
They absolutely are. And if we connect this to the bigger picture, your biological data rights shouldn't change just because your team crossed state lines for an away game.
It makes no sense.
It creates an untenable compliance nightmare for the institutions, and worse, leaves the athletes entirely vulnerable.
And because this data lives in this massive legal black hole, it has become a highly valuable, highly exploitable asset.
Very valuable.
Which brings us to the commercialization collision, the money. Here's where it gets really interesting, because our sources point heavily to the 2018 Supreme Court decision, Murphy v. NCAA, which struck down the federal ban on sports betting.
That changed everything.
It really did. The NCAA has already approved the sale of publicly available competition stats to betting operators. We are talking about data feeds powering live, in-game prop bets. But they have remained noticeably silent on the commercialization of biometric data specifically.
And the mechanics of how sports betting platforms could use this biometric data are staggering.
How so?
Imagine an in-game betting market that isn't just based on whether a player makes a free throw, but is actively fluctuating based on the real-time biometric stress levels of that player standing at the line.
Oh my God.
Right. Odds makers aren't just looking at historical shooting percentages anymore. They could be algorithmically adjusting the spread based on a point guard's live central nervous system fatigue.
That is terrifying.
It is. The Foley and Lardner analysis from June 2025 dives deep into these commercial tensions, particularly how this data collides with NIL name, image, and likeness.
I really want to dig into that NIL collision.
Yeah.
Because athletes fought for decades for the right to profit from their name, their image, their likeness.
Yeah, a long legal battle.
But how does my resting heart rate or my deep sleep cycle fit into my likeness? It is totally invisible.
Well, NIL case law was built around external identifiers we can see and hear. Your face on a billboard, your name on a jersey, your voice in a commercial.
Things you can point to.
Exactly. But the Foley and Lardner piece asks a critical question. If a wearable tech company uses a famous quarterback's unique recovery data and sleep metrics to market their new product, claiming, train using the exact metrics of a champion, are they using his likeness?
I mean, it is his data.
Biological data is arguably the purest representation of who you are physically. If we don't classify biometrics as part of a person's legal likeness, a third party could theoretically license the commercial rights to your physiological identity without paying you a dime.
That is so messed up. And that Foley and Lardner piece also brought up the trade scenario, which completely changes how we view data retention.
Yes, the trade dilemma is huge.
Say a player gets traded mid-season from one professional team to another. When they clean out their physical locker, what happens to their digital baseline?
The former team almost always retains all of that historical biometric data.
They just keep it.
They keep it. To understand the mechanism of why this is so problematic, think of it like hiring a brilliant software developer. They write a proprietary algorithm for your company. When they leave to work for a competitor, you obviously keep the algorithm they wrote.
Sure, that makes sense for code.
But with biometric data, it is like you not only keep the algorithm, you retain the legal right to predict every line of code they will ever write in the future, because you own the foundational map of how their body and brain work.
Oh, wow.
Yeah. The former team can continue to profit off aggregated data sets that contain that traded player's bodily data long after they have left the organization.
As a former player, the irony is just stark. You have college and pro athletes who will fight tooth and nail over who gets the royalty percentage for a jersey sale or whether their face appears in a video game.
Oh, absolutely. Huge legal battles over that.
But meanwhile, their literal heartbeat, their physical exhaustion levels, and their central nervous system recovery metrics are being aggregated, modeled, and potentially sold off by a former institution, and the athlete sees nothing.
Nothing at all. What's fascinating here is that our legal system is currently treating digital avatars, the video game versions of these players, with significantly more commercial protection than a living human being's digital biological twin.
That is crazy when you put it like that.
It is. We have decades of extensive case law on video game likeness rights. We have virtually nothing on the commercialization of a human nervous system.
Okay, so we know this data is highly valuable. We know it is a gold mine for analytics, sports betting, and wearable marketing. And we know it is sitting unprotected by federal law.
A total Wild West.
Exactly. And we obviously can't just wait around for lawmakers to suddenly figure out biometric legislation. We need a governance framework today.
Today, we can't wait.
The December 2025 PMC paper we looked at introduced the concept of an athlete data sovereignty framework built entirely on the concept of joint controllership borrowed from the European Union's GDPR.
Yeah, GDPR is leading the way on this stuff.
So how does joint controllership actually function on a server level? What does that mechanism look like in a locker room?
Mechanically, it means breaking the institutional monopoly on control. Right now, the university or the pro team acts as the sole dictator of the data. They hold the administrative keys.
Right.
Joint controllership says that both the athlete and the institution have equal legally binding say over how that data is used, processed, and shared.
So they share the power.
Exactly. On a server level, it requires physical and software architectures where data cannot be exported to a third-party analytics firm or a betting aggregator without dual cryptographic consent.
Meaning both have to click yes.
Yes. Neither party can sell it or transfer it without the explicit documented approval of the other. It essentially creates a co-ownership model.
Okay, but is this purely academic theory, Or has this actually been tested in a high-stakes sports environment?
It actually has a working blueprint. The PMC paper highlights the 2020 collective bargaining agreement between the NFL and the NFL Players Association.
Oh, really?
Yeah. They established a joint administration model where the league and the union co-manage the biometric data.
So they are already doing this.
They are. If a wearable vendor wants access to NFL player data, they have to pass through a joint committee. If there is a dispute over how data is being used, it goes to a neutral arbitrator, not just the league commissioner.
That seems way more fair.
It is not a flawless system, obviously, but it proves the mechanism works. You can run a multi-billion-dollar sports enterprise while still treating athlete data as a shared asset rather than the exclusive property of the employer.
So what does this all mean for you, the listener, or the 18-year-old freshman walking into the locker room? Do they need a tech lawyer to read a consent form before they can practice?
Well, this raises an important question about who actually holds the administrative keys to these third-party servers. For institutions, good governance requires a rigorous SEC via process for any wearable vendor.
Wait, HECVAT?
Yes, the Higher Education Community Vendor Assessment Toolkit.
Okay, HECVAT sounds great on paper, but I've been in those athletic departments. They are notoriously siloed from university IT.
That is very true.
If a head coach wants the newest wearable technology to win a conference championship this weekend, they aren't going to wait for a 300-point IT risk assessment. They just swipe a department credit card and hand the devices out to the players.
Which is exactly why the governance has to come from the very top of the institution, legally binding the athletic department to the university's overarching IT policy.
You have to be forced to do it.
Right. Athletic departments cannot operate like rogue tech startups. If you bypass HECVAT, you're taking on massive institutional risk. Implementing HECVAT forces the vendor to prove their servers are secure, to explain exactly who has administrative access, and to legally guarantee they aren't selling the data out the back door to a data broker.
Because if they don't.
If an athletic director allows a coach to bypass that just to get a competitive edge on a Saturday, they're exposing the university to massive liability.
Okay, let's pull this all together into a practical playbook based on our sources. We need actionable takeaways for all the parties involved in this wearable Wild West because the tech isn't going anywhere.
It is only going to grow.
Let's start with the athletes themselves. If you are an 18-year-old freshman walking into a locker room, what is the immediate action item?
For athletes, it comes down to 3 non-negotiable questions you must ask before you strap a device to your chest or your wrist.
Okay, what's the first one?
1, what exactly is being collected? Is it just heart rate during a 2-hour practice? Or is it 247 GPS location and off-campus sleep cycles?
Huge difference there.
Massive.
Yeah.
2, how long is it retained? Does the data delete at the end of the season, or does it live on a proprietary server forever?
Right. And the third?
And 3, who else gets to see it? Is it confined to the coaching staff, or does the consent form allow sharing with quote-unquote trusted third-party partners, which is usually code for analytics firms and data brokers?
So if they can't answer those...
If the institution cannot answer those 3 questions clearly, or if the answers are vague, you have to push back.
Now, what about the coaches and the athletic directors?
Yeah.
The people running these programs who are managing this influx of data?
The immediate step for them is internal classification. They need to coordinate with their university's IT department tomorrow and instantly classify all athlete biometric data as Category 1 sensitive data within their information classification policy.
Not just operational data anymore.
Exactly. Stop treating it like operational practice film. Treat it with the exact same cryptographic security protocols, access limits, and retention schedules as you would a student's social security number or their financial aid records.
And finally, for the institutions themselves, the universities, the conferences, and the professional leagues.
Write joint controllership language into all of your vendor contracts immediately. Do not wait for Congress to pass a federal biometric law.
Because it might take years.
Because by the time they finally understand the technology, you will already be dealing with years of mismanaged, exploitable data. Establish those co-ownership models and dual consent mechanisms now. When the regulatory hammer finally falls, your house will already be in order.
To bring this all home, there's a powerful memory mentioned in the sources that perfectly captures the core philosophy we are talking about today.
Oh, the cycling team.
Yes, it goes back to the London 2012 Olympics, specifically looking at the track cycling team from Trinidad and Tobago.
Such a great example.
This was before the massive commercialization of all this tech, before the NIL deals and the sports betting integrations. Back then, The answer to what data sovereignty looked like was remarkably simple and profound.
It really was.
The athletes were the ones generating the data, and so the athlete decided what happened to it. The power resided entirely with the human being generating the heartbeat, not the corporation capturing it.
It is a profound precedent. It fundamentally proves that high performance, elite analytics, and true data sovereignty are not mutually exclusive.
You can have both.
Yes. You can win at the absolute highest levels of global sport while still respecting the fundamental autonomy of the human body.
That leaves us with one final thing for you to ponder on your own. This deep dive isn't just about elite athletes anymore. This technology is creeping into everyday life.
It's everywhere now.
As biometric wearables move out of the locker room and onto the wrists, rings, and smartwatches of millions of everyday people, our own bodies are constantly generating incredibly valuable commercial data.
Data that is just sitting out there.
If the legal system currently cannot even protect a highly visible college athlete's biometric privacy from being exploited in a legal blind spot, are we all eventually going to need a personal data agent just to negotiate the rights to our own biological metrics?
It is a future that is arriving much faster than we realize.
So the next time you see that collegiate athlete strapping on a monitor before practice, just remember, you aren't just looking at a piece of sports equipment. You are looking at the absolute frontier of human data rights.